Hello, and welcome to my channel, The Entrepreneurial Mindset. Today's presentation is called Essential Business Law Concepts, Episode 1. The concepts in this video come from my book, The Manual of Essential Business Concepts, available on Amazon.com, Kindle version only. Go to the Amazon search bar, select books, type in my name, Jay Berman, scroll to my book to purchase, and by doing so, you support my channel and my work in entrepreneurship and business education. Thank you. So today's essential business law concepts, I'm going to discuss state courts, federal courts, civil court trial procedures, small claims court, and alternative dispute resolution. So let's start with the state courts. Every state has trial courts. These are where civil trials are conducted. This is where questions of fact are the issues that prompted the dispute between the plaintiff and the defendant. Then they are the appellate courts. They're only interested in hearing appeals, either from the plaintiff or the defendant, based on questions of state law or judicial review. Appellate courts review cases in which legal errors might have been made in the trial courts. And then above the appellate courts, every state has its own Supreme Court. The Supreme Courts of each state are only interested in hearing appeals, again, either from the plaintiff or defendant, based upon questions of state law or judicial review. State Supreme Courts review cases in which legal errors might have been made in the trial courts. On a state level, the state Supreme Court's decision is final. Then, of course, there are the federal courts. We start off with the U.S. district courts. There is at least one in every state. These judges are appointed by the President of the United States and approved by the Senate. Then the next higher level of courts is the U.S. Courts of Appeal. There are 13 of U.S. Courts of Appeal. There are 12 circuits that cover specific geographic areas, while the 13th Circuit has national jurisdiction over certain cases. Judges are appointed by the President and approved by the Senate. And then the highest court in the land is the U.S. Supreme Court. They may review any case from the U.S. Courts of Appeal and state Supreme Courts. 9 justices are appointed by the President and approved by the Senate. They serve for life, just like the federal courts and the appellate courts. They serve for life. The Supreme Court reviews very, very few cases. They accept very few. Cases. Cases must require some sort of constitutional implication or interpretation of the U.S. Constitution, and their decision is final. There are no higher courts than the Supreme Court. So if you are going to engage in a lawsuit, particularly in business, those lawsuits would take place in a civil court. So I'm going to talk about the civil court procedures. The first one is the burden of proof. The burden of proof falls on the plaintiff. The plaintiff must prove his or her claim with evidence, facts. Then the plaintiff, before you sue somebody, you really need to assess whether the defendant can afford the monetary damages. They might be an LLC, which is usually designed to protect the assets of a business. Aside from LLC, you really have to decide if you're going to sue somebody for hundreds of thousands of dollars, whether if you do win, whether the defendant can actually afford the damages, the monetary damages if you do win. You also have to assess the attorney's fees. They can be fixed. In other words, the attorney accepts a retainer, or they can accrue hourly. So those attorney fees must be payable whether you win or lose. Or perhaps you can sign a contingency contract or a contingency basis where the attorney gets a percentage of the damages if you win, and of course get paid, which again I just previously mentioned may not be a possibility. Or the judge can set the attorney fees. So the question is whether if you're going to engage in a lawsuit as a plaintiff, whether you can afford the attorney's fees. The next step in the civil court trial procedure is the plaintiff's complaint. It starts off with a statement justifying why the court has jurisdiction. That's true for any case. Every case the judge must have jurisdiction in the case. Then there is a statement of facts in which the plaintiff explains why he or she is entitled to a remedy and what that actual remedy should be. The plaintiff's complaint is filed with the clerk of the trial court, assuming, again, there's a proper venue, proper jurisdiction, and then a copy of the complaint and summons are sent to the defendant. The next step in the civil court trial procedure is a summons. So the defendant has 20 to 30 days to respond. The defendant can invoke what they call a defense, in which he or she admits the truth of the complaint. However, the defendant presents new facts to dismiss the case because the legal consequences do not merit a trial to begin with. The defendant can answer a summons with a counterclaim against the plaintiff. The judge can then deny the defendant's motion to dismiss. The judge can rule in favor of the plaintiff if the defendant does not file an answer to the summons. The judge then grants remedy as requested by the plaintiff. If the judge grants defendant motion to dismiss, the defendant need not answer the summons. But then if that does happen, then the plaintiff may amend the complaint. If not, the judge dismisses the case in favor of the defendant. If you get past the summons stage, then there's discovery, which is simply the process of obtaining only relevant or pertinent information from both parties, the plaintiff and defendant, and witnesses in the hope of narrowing the issues of the case. There's going to be a pre-trial conference. So after discovery, the judge discusses the case with both attorneys, both the plaintiff attorney and the defendant's attorney, in order to resolve the case or perhaps clarify the issues and agree on witnesses and evidence. Then there is the jury selection. So according to the Seventh Amendment, which guarantees the right of a jury trial in federal courts, state constitutions guarantee such a right in state courts. The jury selection does not have to be exercised. However, if it is exercised, the attorneys ask questions to prospective jurors to determine their bias or connection to the plaintiff or defendant. Then the trial starts off with opening statements. The plaintiff's attorney goes first. Each attorney briefly represents his or her client's version of the case and of the facts and outlines the evidence to be presented in court. Then there is the examination of witnesses. Plaintiff witnesses are questioned first, and then the defendant's witnesses are questioned next. So you have direct examination, cross-examination, redirect examination, and recross examination. Then you have the closing arguments. So plaintiff's attorney goes first. Each attorney summarizes the facts, the evidence, and the weaknesses in each other's claims. Then the judge then gives the jury instructions. Judge instructs or charges the jury in the law, which cannot be ignored. That applies in the case. The jury can't ignore the facts. Then there's a jury verdict. The jury specifies the factual findings and the amount of damages to be paid by the losing party. The trial ends, and the jurors are dismissed. Then the judge then is entitled to enforce the judgment. If the defendant does not have the money, the judge orders the local sheriff to seize the defendant's property for the value of the award and have it auctioned, or the title, the ownership of that property, transferred to the plaintiff. Now, either side can appeal to the higher court if they think the trial judge erred in applying the wrong statute, the wrong law, or if the trial judge failed to follow legal procedure. Again, this is a very difficult thing to do, to appeal, because judges, they know what they're doing. So the likelihood that they applied the wrong statute or the wrong legal procedure is not highly likely. Now, there are in every state small claims courts, usually in your local jurisdiction, your city, your town. And the nice thing about small claims courts is that it allows you to sue somebody for damages that are worth less than $10,000, maybe $5,000. That limit is based on the state that you're in. You don't need an attorney to file a claim. There's usually a small fee required to file a claim. But just be aware that small claims court judges expect both the plaintiff and defendant to negotiate before filing a claim. So in other words, both parties have to make a good faith effort to negotiate their differences and come up with their own solution. If that doesn't work, then the judge will listen to the case. He or she will make a decision, and then of course that decision is forcible. And just be aware that if you lose, there is no appeal. And also be aware that if you are an LLC, a limited liability company, that may not necessarily protect your assets if you lose, because the judge decides whether your LLC was set up properly. So even if you have an LLC, doesn't mean it's going to prevent a lawsuit. So someone can still sue you even though you are an LLC. And again, the judge will decide whether you set up the LLC properly. And I have a separate video about that. I will link it to this video. And then there are what we call alternative dispute resolution. This is used to avoid the expense of a civil trial. First, there is negotiation. Both parties settle a dispute without having attorneys or the courts. Perhaps you can hire your own private negotiator to come up with a solution with the dispute of both parties. You can hire a professional mediator. Both parties settle the dispute by hiring an expert mediator who proposes solutions. However, just remember that when it comes to mediation, solutions are not enforceable by the courts. If you choose arbitration, both parties can hire an expert arbitrator. But just remember, an arbitrator's decisions are legally binding of both parties. They are enforceable by the courts, and they're not you can't appeal. So this might be neither negotiation, mediation, arbitration would be much cheaper than engaging in a civil trial. And that's all what I have for today. Any questions or comments, please use the comment section below. Subscribe to my channel for more educational content about entrepreneurship and business education. And thank you for watching.